Okay, now I guess the main part of the meeting is going to be discussions with the Attorney General, Ken Cuccinelli. He's issued some opinions, some of which we like, and namely that regarding restriction on carrying in places of religious worship, that self-defense is considered a lawful purpose. And then the other one was that kind of went against us was his opinion on George Mason University's gun ban. But anyways, he's here to talk. What I'll let him do is talk for a while. I've got 3 questions I want to ask him, and then after that, we'll turn it over and let everybody in the audience ask the questions that they want to do. So again, Ken Cuccinelli.
First, I got a couple things I want to touch on. One, the role of the Attorney General. 2, the last time I was here with you all, three years ago, and my own mistake as well. And then touch on GMU, and then get to you all's questions. First of all, there's something that's a little bit unique, a lot unique about the Attorney General's office. And that is that, you know, I've got this bank of clients, all the governing agencies, the governor, the legislators, and so forth. And I don't have to go recruit my clients, which is an advantage from private practice. However, I can't fire them either, a disadvantage relative to private practice. Because my first obligation is to the law, whatever I might like, I end up with some opinions that I don't like, and the word opinion itself is a little bit misleading. But they're what our best estimate of what a Virginia court would say the law is if they got it right. That's what an opinion is from our office. A court opinion is a ruling. A legal opinion from the Attorney General's office is not Ken's opinion of how he would like the law to be. That is a very common misconception. What it is a formal undertaking. We do the research and those sorts of things. And the best way to understand it is our best estimate of what the Virginia Supreme Court would say the law in Virginia is if they got it right.
If they were to. Subjunctive.
Yeah, I was an engineer, so you can have the grammar. I have 7 kids. The first 5 are girls. The youngest is 9, and she's better at grammar than I am.
I'm not correcting your grammar. I'm making an observation about how the court actually rules. Yeah.
Yes, and I'm making it. I'm picking my words appropriately. They don't get them all right, but that doesn't give me any leeway. I have to get these as right as I can. So one way to look at this from my perspective, I have a goal as Attorney General. I have many, but one of them is to never have a court go in a direction opposite one of our legal opinions. And 22 months in, no Virginia court, and they do go contrary to AG opinions, they've done it in the past, no Virginia court has ever gone contrary to one of our opinions. More than that, for the first time in over 30 years, and people can't even remember before that, the Virginia Supreme Court asked us for an opinion in a case where we weren't a party. They have the legal authority to do that. They can ask outside experts for legal input on a question of legal import, and they have done that. They have never, ever before asked a living Attorney General, by which I mean any of the ones still living. Presumably they didn't ask any dead ones. But for that kind of contribution in a case. This fall, they did that with my office. And that tells you what the Virginia Supreme Court thinks of what they get from my office. And it is very important for us, not just to maintain that credibility for maintaining that credibility's sake, but to be right. To be right. To be legally right. That is a very awkward position, and I'll use you all as an example. The GMU case. You become Attorney General, you get all the clients. And if you can defend a position of your client with a straight face, the lawyers would call it the straight face test. There's a legitimate constitutional defense for the position they want to take. Lawyers advise, clients decide. That is no different in public legal practice than private legal practice. The only time I can break from an ordinary client relationship when they want to make a decision that I don't like is when it literally cannot be ethically defended in court. If we do not believe there is a legal or constitutional basis to make the argument, then a lawyer is called on not to make the argument. But that's how far it has to go. And obviously, in the GMU matter, I was not in a place that I wanted to be. GMU has regulations that I don't like. I think they're bad policy. But in light of Heller, they were clearly within the Constitution. The more open legal fight in the GMU case was really about the Virginia Constitution and the self-executing nature of the rights at issue. And that was resolved in the way we thought it would be. And while we're in the case, and I had discussions with a number of you while we're in the case, I cannot undercut my client by going out and saying something like, yeah, I'm doing this because I have to, but I think they're crazy. But the case is over. So I did what my job called me to do, but I think they're crazy. I don't mean literally crazy, but I think the policy they have undertaken does not achieve the goals that they've set, i.e. canvassing. I don't think they achieve them the way they've gone about it. Now, 3 years ago I was here and was reflecting on Dick Black's bill, for those of you who pay attention a long time, HB 1516, which wiped out the local patchwork gun control, so that local governments couldn't pass their own gun control statutes. We're a Dillon Rule state. It means the General Assembly has to give permission for many things to the local governments to do, and they took that one back. Now, when I was in front of you all, I made a legal mistake. I thought the bill we passed 3 years before required any entity in Virginia to go through the General Assembly to address gun laws. And I spoke accordingly, which is why I thought GMU at that time couldn't do what they had done with the regulation. But my mistake, and it was a mistake, was that it only applied to local governments. It doesn't apply to state agencies. So we continue to wrestle with state agencies. I will say, you know, when I was a senator, I was working on parks and state parks and forests, those kinds of things, and carrying in parks and forests. And I got an opinion from then Attorney General Bob McDonnell about one of those subjects, which Tim Kaine refused to allow VCR to put into effect. And when Bob McDonnell became governor, he put in process the removal of that regulation that in his view as AG and in my view was contrary to the law. And so he's cleaned that out. So you know, these elections have consequences. And nonetheless, when I was here, you know, I think it was December 08, I don't remember exactly, but it was a long campaign. I got that wrong. That was my fault. I hadn't pulled the bill back up before I went over here, but I got that wrong. And that's my fault, and I noticed that's caused a good bit of discussion, and that's legitimate, and I understand that. There's really not much more I can say to you than I remembered the bill inaccurately and got it wrong. Not particularly helpful to my comfort level to have gotten it wrong as it relates to GMU, which I walked into the AG's office and had this case already on my desk. Not a really comfortable position. And I've touched on GMU. I would also mention what I've learned in going through the opinion process as it related to UVA, moving to a different university, both alma maters of mine, by the way, one of which would disclaim me at the moment. But They don't get to do that. I hid my degree so they couldn't come find it. The policy question versus regulation at the University of Virginia, how policy doesn't have the force of law, particularly when it bumps up against something like the concealed carry right, which does have the force of law. One thing I learned in that process is that, and I didn't know this before, is that the universities have managed to lobby themselves through the General Assembly what amounts to an abbreviated regulatory process that isn't like any other state agency. They don't have any of the public notice comment type of requirements that all the other agencies have to go through. Now, I don't know when they finagled this. I can certainly guess why, because, gee, it's so inconvenient to actually participate in democracy, at least for the high and mighty in the ivory towers. And that's where we are right now. I don't think there's any good basis for that. I don't think there's a good basis for a number of things our universities do, but this is one that's put in statute that just ought not to be in statute. If they're going to have this regulatory authority and to a certain extent covering some areas, they're going to, it really ought to be curtailed by the General Assembly. And not so much curtailed, they shouldn't be treated any differently than any other state agency as far as the extent of their authority goes. But some of you I know have been concerned, and as I have been, with the fact that UVA just popped right into the regulatory pipeline, if you will, once they got my opinion. And that's when I learned what that process for them, and just them, entails. And it's a lot less than it does for every other part of state government, which I don't think is defensible as a matter of governance. But it's there at the moment. That could be changed. Those are the main points I wanted to hit with you all, kind of the mea culpa in my 3-year-ago statement. But I would point out a couple of things that I'm going to comment on earlier notes. The 2020 Senate. It isn't so much that the Dems were voting against good self-protection Second Amendment bills as that they were breaking their own rules to kill these bills. You know, there are a lot of people who don't like the subcommittee system in the House and that bills can be killed in House subcommittees. But you know what? It's in their rules. It's in their rules. It's part of what you got when you voted for Republicans who are going to be in charge and writing the rules. They have followed their own rules. On the Senate side for the last 4 years, the Democrats didn't change the rules and then ignored them. Even before the 2020 tie, you have what amounts to a friendly, if you take all 40 of them, Second Amendment Senate. I think if you put them all on the floor. When the bills get to the floor, they do pretty well. I don't know the exact numbers, but they do pretty well. It's the committees where they were killing things. And the newly discovered subcommittees who had newly discovered and not written anywhere powers to kill bills, where they were killing things. And this was a Sass law maneuver primarily. He drove this. My prediction here is he will not be the minority leader. He will be out of Democrat leadership. My guess is Donald McKeechin will be the leader for the Democrats. And as liberal as you thought the Democrats were when they had 22, they're going to be more liberal at 20. That will be kind of interesting to see. Their caucus dynamics are really something to behold. It's really kind of a cage match in there. And I think Saslaw is just going to say, forget it. I don't even think he's going to put up a fight. But they're not going to make the rules, and they're not going to enforce the rules. For at least the next 2 years, the Republicans are going to do that. And I would be astonished, even the Republicans that I've had run-ins with on Second Amendment issues when I was in the Senate, if they don't follow their own rules. They have a big leg up on the Democrats because the Democrats didn't follow the rules. There's real moral authority there now to tell the Dems, even at 2020, no, you don't get committees. You're down 8-7 on all of them. And I think they're going to do that. maybe 9-6 on a couple, but that arises heavily out of how the Democrats acted for 4 years. And that affects the issues that you guys care about. The one I've been asked about the most lately, because I've been around campaigning all over Virginia for Bill Stanley and others, Dennis mentioned, is the Castle Doctrine, which I think is finally going to come out. And I assume Governor McDonnell will sign it, which we've been working on for years. I mean, I've been working on that when I was in the Senate a number of years. So those are things that I think you're going to see a more friendly reception, not so much because there's so much better votes. I mean, you lost Roscoe Reynolds and Ed Howe. They weren't, now that they're gone, I'll say it, they weren't bad on gun issues. Bill Stanley and Bryce Reeves will be just as good or better, a little bit better. But where you get the difference is you don't get the committee games that are used to kill bills. You've cleaned that out, and it's a worthwhile lesson to realize you haven't swapped out, you haven't lost any. Let's just treat them as equal, just for purposes of discussion. Not that I'm doing that. You haven't really traded much up or down on individual senators' gun votes, but the change in control is going to change the prospects for good Second Amendment legislation. And it'll be an interesting test for some of these folks. It is not a conservative Senate. It is a Republican Senate. And boy, nobody knows that difference more than I do. Upside the head over the time I was there. When I was there 7.5 years, I had 10 times the fights with Republicans that I did with Democrats. And some of them are there, and they're running the Senate. But they're not running it alone. They're not running it alone. They're going to be, there are going to be conservative committee chairs, not not courts. Tommy Norman's going to chair courts. And Tommy isn't 100% on board with our issues, but he's actually gotten pretty good because of the support of the pro-gun community over the years. And as a majority leader, or a Republican leader, he is accommodating the supportive groups of the caucus. So you got cards to play there now that you didn't have. So, and I don't expect Tommy to do what Dick was doing, make up rules to kill bills. That's what they were doing. So it's going to be kind of a new day when we get there in January. It'll be, 2020 will never be boring. It will never be boring. And we'll have to see how some things play out. But y'all's issues aren't party line vote issues. So there's always going to be, you're always going to be working for Republicans and Democrat votes. And for the other bills, working to kill bills. But with a 68 Republican House, why bring a bad bill that you're going to take a beating for and never get out of the House? Maybe there's a reason for that, but not typically a good one. Second Amendment issues are good issues for people who want to get elected and who care about freedom and liberty. And frankly, there's sort of a revival of that, if you haven't noticed, in the last couple of years. And that's something that I have tried to be involved in more broadly as Attorney General. So, with that, you wanted to start with some questions. I think I answered one.
3 questions. Ken answered one or addressed one that I had raised to him. That was regarding the UVA regulation process, where they're implementing a regulation and implementing something in the Virginia Administrative Code without having any kind of public comment or public notice period, and they're just implementing it. And so you're saying that that appears to be okay.
They appear to have their own special regulatory process where the universities do that is totally abbreviated relative to other state agencies.
All the state universities?
Yeah, it is. It is not. There are statutory things that are unique to particular universities. Not many, but there are a few. But that is not one of them. So it's all the public universities. I mean, Liberty just changed their gun policy too. They went the right direction.
Good brother. Well, it started.
Yes, they are. Yes, they are. We don't. The General Assembly can legislate there, but they have not chosen to do so in the past. I don't expect they'll do it. So, I mean, they in Christendom have had pretty open policies for years with no negative instinct. So, as has one of the publics. Blue Ridge Community College. Blue Ridge.
Let's see, the two other questions. One recently passed by the General Assembly and signed by the governor was a law allowing individuals to carry a loaded firearm in a, originally it was passed as a locked container in their vehicle, and then Governor McDonald suggested an amendment to change locked to secured. Some judges are interpreting secured as the same as locked. It's got to be under a key. Others are interpreting it as being closed. So the question that we'd all like to know is, what is the difference between locked and secured? Is secured simply in a closed container?
Well, I've learned a lesson that I shouldn't give legal opinions necessarily off the cuff. I think I was standing here. I'm not exactly prepared to answer that completely. I will speak to one general precept of interpretation, because when you get an amendment, it means something. And so secured, amended as from locked, shouldn't just mean the same as locked. But that's about as far as I can go at this point. I didn't do that.
Okay.
Can I suggest something on that point and perhaps get a reaction? I have a case pending right now in Loudoun County involving just this issue. I have gone through every opinion of every appellate court in Virginia, every circuit court in Virginia, and every section in the Code of Virginia, looking at the word secured and how it's used. And so I've got a motion to dismiss in a case pending right now in Leesburg on just this issue. There are three definitions of the word secured. One is that, for example, a promissory note can be secured by a mortgage, and that it's like a synonym for to vouchsafe. Another definition is
collateral.
Yeah, well, it's you're giving somebody a sense of security because they can exact someone.
No, okay. I won't argue it because that's not the important.
Yeah. The second one is to obtain something. So, for example, if you went to the cabinet and secured a bottle of whiskey.
Lousy example.
The third instance is where something is kept from flopping around or being loose. And that's the one that's important here. For example, there's a statute that requires a child under a certain age to be secured in a child safety seat. I've got a 5-page memorandum full of excerpts that illustrate that use of the term. And my conclusion is the word locked is a more specific term than secured. They are not synonyms. You can secure a gate by putting a lock on it. You can also secure the gate by putting a rope on it. So the word secured means closed. And in fact, in this particular case, the deputy was arresting my client and asked the magistrate said, well, you know, if you put it in a Ziploc bag, that is secured in a container in the vehicle. That's legal. But she wants to create a test case because they don't like the fact that it's...
Who's she, the deputy?
The deputy, yeah. And the Commonwealth Attorney showed up and argued with me and wants to do his own research on this point in opposition to my motion. So they're still experimenting on my client because they want to test this. Huh? Loudoun County Sheriff's Deputy, yeah.
This is obviously something we don't want is individuals to have to go through this process. It should be clearly defined.
Well, I will tell you, jumping back to our legal opinions, the point of them is clarity. Whether you like the opinion or don't like the opinion, it's important for us all to know what the rules are. We all have to know that. It's not fair to play gotcha with the law. Now, I will tell you, just for process purposes, when there's litigation pending, we don't issue opinions. Because while our opinions are of greater persuasive force than anything any other lawyer in Virginia might say, they're not binding on courts. So we wait for the court.
I was really looking for a reaction to my analysis.
Well, my first thought was in your second example of securing, I'm sorry, the child safety seat. I was thinking my 3-year-old. I thought locked might work better. That might just be personal. I don't think your logic is faulty. That doesn't mean the judge will come to the same place. But what you just walked through, I think you've mooted us all well, and you're ready for court. So that's about, especially relying on the code as it exists, probably the best you can do. So, who's the judge?
Ken. And I'll tell you, on the expression on her face, she was ready to rule that moment after she read my 10 pages of stuff. Nobody files this stuff in the general district court but me. And she actually read it all. And she looked at the Commonwealth Attorney like it was nuts when he said he wanted a chance to rebut it.
Sounds okay.
I think we're headed in the right direction.
Well, was it the CA or a deputy CA?
It's a deputy. I can't remember the deputy. It wasn't Jim Plowman.
Okay.
Yeah, but for one like that, ultimately the CA makes sense.
Josh Stewart was the deputy.
Ken, when the governor asks for an amendment like that on that language, does he also issue a memorandum in support of it or something of that nature?
No. He will sometimes issue just a statement and say, this is why I'm doing this. Sometimes he even checks with us first.
Well, the legislative history is not admissible.
No, it is not in Virginia.
But Webster's Third International Dictionary is admissible.
They will take judicial notice of it. Yes. Yes, one of my favorite founding fathers, Noah Webster. Doing all sorts of things to befuddle the federal government in our healthcare case. Defining words all over the place. Dennis?
I'm a little confused. I've been very busy. I haven't paid full attention. This ability to regulate in universities, public universities, the ban inside buildings versus a ban in common grounds outside. Do they have regulatory authority to just completely ban on any property they have?
No, I'll tell you, just to be cold-blooded objective, GMU was very surgical about how they went about it relative to the existing case law, which is basically Heller. UVA just closed their eyes and said, everything. And so it's a lot tougher for, I mean, think about Heller. They said schools and government buildings, and of course public universities are both. They didn't say anything about roads, they didn't say anything about sidewalks, they didn't say anything about public access ways.
Parade ground.
And GMU didn't touch those. They stuck with those things that Heller gave indications they could get at. In Heller, I was in the 4th row for Heller. It was very interesting to read that because part of me wonders, did they make a deal on the language to get vote number 5? And, I don't know if we'll ever know the answer to that question. But parts of the opinion suggest to me that they had to offer up a more restrictive perspective, forward-looking, than maybe most of the majority would have wanted to get that 5th vote. I don't know if that's the case, but when I read Heller, and it's a long read, that's one of the things I certainly am drawn to wonder. So.
The last question that I had, but before I do that, let's see, we've got one person from the news media here. Are you also from the news media?
Yes, I am.
Yeah, they don't get that.
Just wanted to make sure the news media was here and who they were. The last question, in a way, it addresses the Virginia Administrative Code. Is back in 2006, we provided Attorney General McDonnell a list of, I believe it was 14 items in the Virginia Administrative Code that banned the possession, carry, or discharge of firearms on state properties. And we couldn't find any statutory justification for that. Now, there's one thing that we were looking at is whether or not, because in Section O of the concealed carry law, it says basically that your permit does not allow you to carry where otherwise prohibited by law. And since Virginia Administrative Code has the force of law, we were looking at changing, see if we could change that wording to statute instead of law, so that basically it would have to be something passed by the General Assembly for the Virginia Administrative Code to restrict the possession, carrying, or discharge of a firearm by a permit holder.
Yeah, first of all, the General Assembly certainly can bring right back to itself all authority over all gun regulation if they chose to do so. And to put it simply, from my perspective, I wish they would. I mean, we did it with respect to local governments, now we should do it with respect to the cities. And that's the universe.
Absolutely, that's what VCDL would like to see, is because, again, we think that we understand the state law, but then there are all these little Virginia Administrative Code that have unique gun bans, and UVA is obviously one that is creating one.
Just for purpose of information, remember all of these, let's say you're on the wrong side of those administrative, they're all civil. You know, they don't get to create new crimes. No one but the General Assembly can do that. So, you know, the GMU example, if you're violating their gun policy, their gun, see I'm falling into words, the regulation, then all they can do is ask you to leave. And if you don't leave, they can hit you for trespass. But that's it. It's not a gun law violation. It's a trespass violation. So be aware we're kind of in a different league in terms of.
But we don't want to have any of that.
You.
So now what I'd like to do is turn it over to the audience, and everybody can ask Ken the questions.
Sorry, yes.
Thank you. Thank you for coming. Go Eagles.
That would be Gonzaga Eagles.
I don't mean this to be a smart
WCAC championship.
I don't mean this to be a smart big question, but when you consider that Virginia courts do get things wrong sometimes,
I have noticed that.
and you do have some judges that are activists, how important is it really that they've never disagreed with you? Couldn't you both be wrong?
Yes. Yeah, absolutely.
Typical lawyer question.
Or logic class, you know. We're just trying to minimize it. We try as hard as we can. Our first goal on any legal question is to be right. Right is defined as the answer correct under the now existing law. And it's almost, well, now existing law is okay. But you know, when the Constitution changes because judges decide things differently, we're stuck with that standard, even if I don't like it. But that's the standard we're operating under. And we, you know, again, I have great fidelity to the law. It's, I believe, the first obligation of my office. And I won't sacrifice that for anything, because I don't think that helps anybody. You know, if you think you can get cheap, easy opinions your way because your guy's there, what the heck does it mean when the next person's there? They owe the same obligation. And I will use a now live example. U.S. Attorney General Eric Holder. And not the one you all talk about the most, Fast and Furious, the Defense of Marriage Act. And I'll use this as an example for this reason. For the first, 18 months of his tenure, his name was on the defense of the Defense of Marriage Act. That tells me that he and his department believed there were legitimate bases to defend the Defense of Marriage Act, which I believe there clearly are. As the sitting Attorney General, to not defend it, as they decided to do going forward, I already told you the standard. You can't have any legitimate argument on your behalf. That's the job he signed up for, and he abdicated it. That is not doing your job. That is not fulfilling the duty of that office. If you don't want to defend that law, quit. Resign. Otherwise, do the job that you said you'd do. And he
Yeah,
hasn't.
you say that because you have moral standards.
Yeah,
So I'm not a lawyer, so I don't have to bow to the courts intellectually. Maybe I do with the guys with the guns. And here's my question. And I asked Alan this question a couple years ago. If the Supreme Court in between November 2012 and January 2013 decides a case in which it says that a 29-year-old can legally serve as president, why do people in the executive, the guys with the guns who go out and enforce the court decisions, why don't they have their own constitutional duty and right and power to say, your decision is just your opinion, it's not correct, and we're not going to enforce it. In fact, Andrew Jackson did it, and he was a hero.
Andrew Jackson did do it. He didn't enforce one of their rulings, famously saying Chief Justice Marshall has his opinion, now let him enforce it. I would note that the refusal to enforce, and I'm not casting judgment, Andrew Jackson's a very interesting character historically, that is one of the ways you get a balance of power. That is part of the separation of powers between the executive, judicial, and legislative branches, or as Chuck Schumer would say, between the executive, the Senate, and the House. He has a different separation of powers, than most of the rest of America. You know, that exists out there. People ask me about state equivalents of that. Again, as a sitting Attorney General, I can't advise people not to obey the law, and including to enforce it. And in Virginia, that means the governor. People run for Attorney General all the time as the top cop. Those of you who remember my campaign, you will remember that didn't happen, because I'm not. The state police work for the governor, the chief magistrate of Virginia. It is an old, you know, it's just a political marketing trick. And I refuse to buy it. It's intellectually slippery, and I just can't. I slept better without it. Let's put it that way. And it turns out, it worked out just fine for us. So, yes, sir.
I was a delegate at your convention. John Brown, sister, Bobby, older brother,
Sister or wife?
I thought it was sister. I could be, he told me, I mean.
Oh, all right. Well, I'm actually going to lie about that. Hopefully not a girlfriend. His wife pulled a lot of votes for me.
Her argument, by the way, I was thinking, wow, maybe she should. Her argument was that you had never been a prosecuting attorney. And I think we've all been delighted with your tenure so far. Has that really been a problem with you at all?
It's absolutely not been an issue at all. I manage prosecutors. I have argued a couple of cases. It's November. I argued them in September of this year, which is the first time I've argued those as AG. And actually, I don't know. You have to go back a long way for another AG to be in court. But you just don't need to be a prosecutor. I'm not. My job on a day-to-day basis isn't to go put a case together. I manage a 400-plus person law firm that does every kind of advising you can imagine for a 130,000 roughly person entity that is the state government of Virginia. I also, and the biggest section is law enforcement, but I don't prosecute those cases. I manage those prosecutions and appeals and law enforcement operations. Doesn't mean I tactically manage. I don't say, okay, we're going to deploy this guy. I know better than to do that. I'm at least that smart. No promises above that level, but at least that smart. And if you go in with a sense of how Virginia law operates, and remember, I was on the courts committee for 7 sessions in the Senate, and in the thick of an awful lot of contests in the Senate. There has been nothing new to me in law enforcement and my law enforcement duties, because I do have them, as Attorney General, that I hadn't touched on or been educated on while I was in the Senate. You know, it's a marketing pitch. It was the advantage he had over Dave Foster and I, and it was ancient. And I'll tell you a funny story about it. As we were going around, as you know, we had a convention. Convention delegates are elected by locality. If one guy comes from Henrico, he votes all the Henrico County votes, all of them. If 100 people come from Henrico, they split them 100 ways. So you literally have a campaign for every single locality to get support for the nomination. So we're in Henrico County. Importantly here, home of Jim Gilmore, who had been the first person to run this way, the top cop routine, because he had been the Commonwealth's attorney for Henrico. And his political consultant was Boyd Marcus. Yeah, Dennis is laughing there. And Boyd Marcus in my race was Dave Foster's political consultant. Dave Foster hadn't been a prosecutor either. So I spoke and I gave my usual, my stump speech, and I was the only candidate there. So next went Delegate Jack Reed, who is really a pistol when it isn't going off in his office. That's that guy. He spoke for Brownlee and did the "you must be a prosecutor" routine. And so Boyd Marcus got up, because he lives in Henrico, and spoke for Dave Foster. And this is the funny part. He got up and said, "You know this whole top cop thing? We made it up! And I ought to know! I made it up!" This is Boyd giving a speech. I wish I'd stuck around for it. But, and he went into the whole spiel about why it happened. It's good marketing. It's great marketing. I mean, the most prominent endorsement that I had in terms of our advertising was the Fraternal Order of Police. Because it matters to people. It matters to people, especially at the bottom of the ballot, where it's very hard to penetrate, and people don't fully appreciate what an Attorney General actually is called on to do if they're going to be good at their job. And it isn't to go into court to prosecute criminal cases. My opponent had been a prosecutor for nearly 2 years out of law school. I think he may have hit felony cases by the time he left that practice. But you'd have thought he was John Wayne and Wyatt Earp all rolled into one in his commercial. And he had that advantage on paper, as it was 2009, by 2009 in November. The same arguments, and some of you have helped me make them indoors in Fairfax running for the state senate, based on first principles and how they matter to our governance. History had caught up with the way I campaigned by 2009. And I made the point that we were going to do a number of things in the area of public safety. But, hey, Virginia, don't forget liberty and the economy. And the economy matters a lot now. It mattered a lot then. And we have a role to play in keeping Virginia a good free market state. We do well compared to our sister states for some very good policy reasons. And the Attorney General has a lot to do with that. And I emphasized a lot of that. Not saying, forget about law enforcement. I just said, we're going to do the job here. And the truth of the matter is, there wasn't a whole lot of distinction between me and my opponent. I'm sure you're all shocked to learn that we were both against child pornography. We were both against, fill in the blank. There just wasn't a lot of difference there. He had done time. He had spent time. Great 12 reporters going. He had spent time as a prosecutor in Fairfax, and that was a distinction. And it is not your relevant experience for the job, but you're not going to do that job as Attorney General. And I have focused on bringing good business practices and management practices, including on the law enforcement side, including business planning, strategic goal setting, with metrics that you can actually measure, and then performance review. And I'm a little surprised with how much room, frankly, there's been to bring those kinds of practices to bear in the Attorney General's office. And we have focused an awful lot on that. So, yes, sir.
Two things, Mr. Attorney General. First off, thanks for coming. One thing that you said about the Senate becoming 2020 is that they're going to be even more liberal, and in the context of gun rights,
well.
somewhat.
No, I think the Democrats as a group.
I'm sorry. You're right. The Democrats are going to be more liberal, and in the context of gun rights, that somewhat disturbs me because I'm a liberal, and you see what I got.
Yeah.
Liberal does not necessarily mean anti-gun nor anti-moral.
Yeah, well, we can debate.
Comment to Eric Holder specifically.
Since Dick Saslaw and Sarah Marsh have broken those Senate rules, why did your office not?
Because it's their rules. The Senate governs itself. The Constitution says that is all hermetically sealed within the Senate. Some of them, to demonstrate their respect for the rule of law, would tell you that's the rule of 21. Think about that a moment. Whoever has the majority of votes makes the rules. Do you remember Calvin and Hobbes? Remember that comic? Yeah. Remember Calvin Ball? The rules of Calvin Ball were whatever Calvin said they were. And they changed in the middle of the game. And they were playing Calvin Ball. But they had the authority to do it. They had the authority to do it.
Calvin Ball had one firm rule. They never played it the same way twice.
Well, that's true. Yes, ma'am.
In your statement previously, when you say you don't actually prosecute men, the Supreme Court hearing in March on the health care plan, and you were right up front with everything. Are you going to go and, you know?
I have not argued those cases. I tell people I'm the hit by a bus plan. The Solicitor General has been arguing for Virginia. Now, just so you know, Monday the Supreme Court said they were going to hear those cases. Virginia's was not one of them. We're in conference next Tuesday. Our case is in the conference, and that means the 9 justices will sit down and talk about our case on Tuesday. Interestingly, this shows you how much they love me up there in Washington. They filed all their briefs in all the other cases early, except Virginia's. And so they all got put together on the calendar on November 10th. And ours was fully briefed, and we waived the reply to accelerate the process. And we're not put in that conference. Yeah, they love us. So and that's the Department of Justice, not the Supreme Court. So we will learn what our role is there. We have a unique issue, separate constitutional issue, which is a state sovereignty issue. The Fourth Circuit said that Virginia didn't have the standing to defend its own law. We have a law that says you can't be ordered to buy health insurance against your will. It's a condition of anything, be it employment or otherwise. And the Fourth Circuit said there's no injury. You have to have an injury to have a lawsuit. Now, you and I have constitutional rights, but we don't have a code of laws. The Commonwealth of Virginia, as a sovereign entity in our constitutional system, has its own code of laws. And the Supreme Court has recognized the uniqueness of that feature and the importance of protecting the state's right to protect it. No, forget health care. No court of appeals, nor the Supreme Court, has ever denied a state the right to defend its own code of laws until the Fourth Circuit did it to us in the health care case. So that is a state standing issue. And that will probably, if we go up, it'll probably be to address that issue while the other states, our sister states, 27 of them, address the individual mandate, and the NFIB addresses an individual standing issue. Anti-Injunction Act, I won't go into that, but so there are other issues there. And as it is, we started out and got the ball rolling, really, on the individual mandate, in a very important constitutional question. And we've sort of stumbled in, we didn't stumble into it, but the Fourth Circuit has delivered us up a second very important constitutional question, which is really one for us. Let me jump around the room a little bit more.
I'll use my word choice right, not your opinion, but what is your thoughts? Last year, I mean, as a former senator, as a gun owner, as a VCDL member, last year our big hit button that we took to the legislative session was we wanted to be able to carry back in restaurants, and we got that. Right. If you were just
I carried that bill in the Senate.
Right. What do you think should be our top 2 or 3 that we should go for this time? Not as not as the AG giving an opinion, but just.
No, I hear you. That's a good question.
I mean, personally, I think, I
I
want to
mean,
be.
I'm kind of biased because of my own experience. I would go with the administrative, and let's get rid of the patchwork and see if the General Assembly will take back all regulatory authority over Second Amendment issues and take it from state agencies, because they are, you know, remember who the biggest lawbreaker in America is? It's government. Of course, that's why there is a Second Amendment. It's a big part of it. Self-defense is part of it, but you know, you could defend yourself from all sorts of entities, and we do not have a track record in Virginia of agencies that frankly behave themselves, or governors. I mean, Governor Kane got an opinion and said this is what the law is. Your agency's breaking the law. I think it was state forests. Parks are forests. They're different, but it was one or the other. And he instructed his agency, don't obey that opinion.
You can see how special universities think they are, because Penn State got itself an exemption from the FOIA Act in Pennsylvania to cover up all this nonsense.
Yeah, well, and they're accommodated. They're accommodated. And they shouldn't be. They should be treated equally under the law like everybody else. And they're public universities. We pay for them. We should be able to see into the work they're doing like you can anything else in government. And it is amazing how much they resist it. Pathetic, but it's amazing.
Some discussions about castle doctrine and so on. One of the things that I have described Virginia as being a standard ground state, standard ground doctrine. I'm not sure.
Could you speak up, please?
Yeah, I'll restate it.
Can you elaborate on the difference?
He asked about the difference between a stand your ground doctrine and a castle doctrine. Stand your ground is anywhere, for one, and it is it doesn't go quite as far as a castle doctrine. The castle doctrine says in your house, once somebody comes in your house, you know, forces their way in, whatever it is, breaking and entering, then the usual legal analysis of did you use appropriate force is set aside, and a new analysis is put in its place. And that is that you may use all force you deem necessary at the time, and the second guessing that will come behind you from a court or a prosecutor is insulated. You will typically be required to have had knowledge that you didn't need to use this much force to protect yourself. So the burden of proof shifts dramatically in favor of the person defending themselves in their home. The stand your ground doctrine is a step down from that. It is, you know, it depends how far up the ladder you want to go. I think we'll get the castle doctrine this year. I presume we will. We'll have to see. You know, an 8-7 courts committee, there's no guarantees, but I would think we should be okay. Yes, sir.
You mentioned the GMU case. You mentioned that by their regulation, you can be asked to leave. You can be asked to leave, and then you don't leave trespass.
Right.
What are the differences? And you mentioned Heller in regard to. What are the differences between that school and other schools?
You mean GMU?
GMU and others, any other school, an elementary school, any other school?
Well, as a matter of law, nothing really.
I mean, the feds, don't they have their federal issues?
You know,
K through 12.
It's funny you ask that. There are 4 Commerce Clause cases since the New Deal, and that's what the healthcare case is about. It's not a 10th Amendment case. You hear it discussed that way, but it's a Commerce Clause. One of them was gun-free schools, and it was in 1995. It was the Lopez case, and the limited government side won that case. The federal government tried to impose the requirement on states and local governments that they must have this 1,000-foot or whatever it was gun-free zone, and it was challenged. I think Lopez was the defendant, and it was defeated. The majority said there's no commerce here, and what the U.S. government at the time was saying was, well, if people can't learn, they won't be prepared for jobs, and it'll affect the economy. And, no, literally. And I think it was Justice Kennedy who said, you cannot overcome this analysis by simply piling inference upon inference, was his phrase. And, you know, in the healthcare case, everybody assumes that the federal government always wins. In those 4 Commerce Clause cases since the New Deal, we're 2-2. We're 2-2. And 3 of them have been in the last 16 years, and we're 2-1 in those. And we is the limited government side. Those of us who actually think the Constitution actually imposes limits on the federal government's power. Imagine that, shocking. But I will say, though, in the last Commerce Clause case, the Raich case in 2005, Justice Scalia was with the majority on the pro-government side. And that Raich, R-A-I-C-H. So that, you know, I'm paid to be nervous about some things. That's one of the things I'm nervous about.
So if somebody goes in armed to an elementary school, what is their liability?
Well, we have some state regulation on that, and the state is allowed to regulate. The federal government can't tell us to. And honestly, I know there's restrictions. If I cited you some, I wouldn't get others. I mean, I know you can come pick your kid up now and keep the gun in the car, that kind of thing. But
yeah, I know how that reads, but I mean, I guess what I'm confused about is going into a GMU building as opposed to going in an elementary school building. Is it the same?
Yeah. Now, I'm really working from memory here, so.
I think the difference is there's a statute. Virginia has a statute, a law.
With respect to
a Class 6 felony if you carry a firearm on school property, except for some exceptions.
That's K through 12.
Whereas GMU is under Virginia Administrative Code. So there's 2 different things. One's a statute and the other is a regulation.
You've got a statute in place, you have criminal penalties.
It says K through
Regulation,
12.
you can't.
Yeah, yeah.
How about a thing?
I don't know. Standing here, I thought that was you have your hand up?
Yes, sir.
Okay.
I want to thank you for calling on the guy with the camera. Sometimes that's dangerous.
I'm not a terribly safe player, so.
I have a statement, and it's kind of sarcastic, but you say you were not the top cop, but Commonwealth Attorneys, by the work of the Senate and the House, have been able to carry firearms
Yes.
untrained, and they're not law enforcement.
They're effectively treated the same. I mean, the reason for that, that's not an old statute. The reason for that was that particularly because of our gang prosecutions, we're getting more and more danger to prosecutors. Hasn't arisen as a executed on threat yet, but I can tell you because we do prosecution in the gang area, along with computer crimes and healthcare fraud. There are areas where we do frontline prosecution, and that's one of them we do alongside Commonwealth Attorneys. That was the motivation for that.
Why couldn't they just go through the process of getting a permit then?
They could. There you go, thinking logically.
And
would have no place in government.
My second thing is a question. In your defense of the GMU regulations, it had a lot of rhetoric that was kind of anti-gun, blood in the streets, dance, kind of stuff. Your name was at the bottom of that brief.
Well, my name's at the bottom of every brief, which is one thing on paper. I'll tell you, it was a little weird when I was in the courtroom hearing myself be sued over and over and over in all these cases, as they were called. But I know the language you're talking about. I realize that case started before I became Attorney General. And what ended up happening is the brief used, I guess it's from October of 2009, I think that's the time frame when the case was being considered by the Supreme Court for whether they would grant the appeal, meaning hear the appeal or not, was just reiterated. And he's not here, but Phil Van Cleve brought that language to my attention. And I read it, and I was pretty shocked by it. And I told my Solicitor General to fix it. The brief went in. His fix was to note our respect for law-abiding gun owners and so forth, but he didn't take any of the language out. So, you know, he does still have a job. You know, I stood here and told you about my mistake. I joke with people that one of the very first campaign promises that I kept was that I would make mistakes. And I have dutifully kept that promise repeatedly. But, so I don't, you know, fire people for what I consider to be individual mistakes. There are exceptions to that. But, you know, I own those because, as you know, my name's on the bottom of that. But I agree with your perspective on it, what I can tell you now. It's not a perspective that I hold. And I know that when that thing was originally written, they were just throwing in everything in the kitchen sink they could think of.
And that's not me personally asking that question. I've had many folks ask me to ask that question.
You're not the first one to ask me either. So.
And I thank you for coming
But now
tonight.
that the order's out, I can actually talk about it. Yes, sir.
Yes, and you mentioned early on that these folks are clients and you're more the attorney. Yet, I think in this case, didn't the people who drafted that information, weren't they
You talking about
legally
GMU?
your employee? Yeah.
Talking about GMU?
Yeah.
Yes. Yeah, that's my point. That's the brief.
But so some of these folks are not just clients; they're also, you have some responsibility for them.
Well, the lawyers, sure.
Yeah. What I'm wondering about, I've run into this before in the federal government. Might there be some way of better organizing all these hundreds of employees you have, many of whom are in positions where they're more likely to listen to the client than to whomever is supervising them?
One of the management challenges for an attorney general is client capture. And there are all sorts of ways this happens. It comes down to the individual attorneys. But, you know, most of our lawyers are in the Richmond office. University counsel are often located at the universities. And they develop somewhat independent relationships. We want our lawyers to develop relationships with their clients, but we always want them to remember that they are the attorney for the client, not the client's representative to the Attorney General. And that is sometimes a battle. It is one I'm cognizant of. And that, you know, I won't single out examples. We have made a lot of progress in remediating those sorts of challenges where they exist. By no means all of them. There's still plenty of work to do. But, you know, these aren't things you flip a switch and change. And when I was talking about business practices and changing management structure and approach, this is some of what I was talking about. I'm going to take one more and then I'm going to actually go home if that's okay. Yeah.
I was listening to your comments earlier, and it occurred to me that I'm sort of tying together two streams of thought. I made the same mistake with respect to 15.2-915 that limits the power of local governments. But the title of that statute makes it sound like it applies to every government agency. Yeah. But then there's a statute that says catch lines are not part of the law. So that doesn't apply. So it's just localities. Right. And that statute incorporates authorities as well as localities. And there's two kinds of authorities. There are authorities that are public, governmental agencies. There's other authorities that are simply set up to manage something. The Dulles Airport, the authority.
Yeah, they typically have, they're treated as political subdivisions, even though they're not counties and cities.
Right.
Yes.
So as to those guys, 15.2-915 applies. And what I was thinking is that universities have this special privilege because of it's a historical thing dating back to the 13th century when universities were sort of invented. They exist essentially as municipal corporations. It's a fairly new wrinkle to call them a public agency or a state agency.
Right.
What I'm thinking is perhaps a statute that says, well, they're not state agencies, they're authorities, thereby placing them within the purview of 15.2-915.
Well, okay, but we're just talking about Second Amendment gun control regulation, realize what you just said has enormous other implications all across governance of universities and management of them. So in solving one problem that way, we would run into a brick wall of 1,000 others.
An alternative would be to say they're local governments, they're municipal corporations, just like the city of Fairfax.
I just kind of like bringing all state agencies' authority to deal with this issue back into the General Assembly. Then they're accountable. I mean, you don't vote for bureaucrats. You vote for senators and you vote for delegates. And, you know, just like we did this year, you vote them out. It's hard to do, doesn't happen a lot, but it does happen. And it's amazing how motivating seeing your fellows go down is. I'll tell you, it changes behavior. So I want to, on that front, I want to commend you all, particularly for your grassroots organization and approach and contribution. You know, I've seen NRA that, I know there's others here, you know, they're kind of the 800-pound gorilla. They don't put anybody on the ground. And as somebody who has run in 4 races and been outspent in all 4 races and won all 4 races, I can tell you it's because of people on the ground who share my commitment to the first principles of this country that really have made us exceptional, even though some people would either like to claim we're not, or would like to stop us from being so. And you know, those are battles that aren't going to end anytime soon. So I really appreciate you all weighing in to these issues and others, and to making it matter in campaigns, where you know the ultimate accountability in our system resides. So thanks very much. I appreciate you having me here tonight, and God bless you all.
Thank you.